Well, all right, everyone. I guess we're now ready to begin our afternoon with the session number 2 entitled Aviation Safety and Security. This session will be moderated by Mr. Jae-Yoon Lee, the Associate Professor from the Chinese University of Hong Kong. Let's first welcome the moderator to the stage with a big round of applause. And I'll continue to introduce our 4 esteemed speakers to you. First of all, we'll be joined by Mr. Benoit Verhagen, the Senior External Relations and Legal Officer at the Legal Affairs and External Relations Bureau at ICAO. Welcome. And moving on, we will invite to the stage Mr. Kang Won-bae, the Director of Aviation Investigation at Korean Air. We're pleased to have you, sir. Please join us on the stage. And now, let me introduce Mr. Denise Kim-dong, the Deputy Director of Monitoring and Oversight at the Air Navigation Bureau of ICAO. Welcome. And now, as for the last but not the least, let's welcome Mr. David Willa, the representative in Singapore of European Union Aviation Safety Agency. Let's welcome him with a big round of applause. And now, I would like to pass the microphone over to our moderator, Mr. Jae-Yoon Lee. Sir, please.
Thank you. Good afternoon, everyone. Also, good morning or good evening for following this by YouTube. So, it's my pleasure to moderate ICAO legal seminar. I'd like to thank the Ministry and Land and Infrastructure and ICAO and Transport and ICAO for your kind invitation. Before we start this important session, I would like to say a few words. One source of great pride in my life is the fact that I have attended all of the ICAO legal seminar in Seoul in 2006, 2009, 2012, 2015, 2018, 2022, and 2024. I have found 2 photos that were taken at the 2012 ICAO legal seminar, exactly 12 years ago. Can you please put that photo on the screen? So I can see many familiar faces who are attending here as well. Can you raise your hand if you can see your younger face? Yes, great. So can I invite the audience to give them a round of applause for their consistent support to this seminar? Thank you. The other photo, next one please. I want to share with you is this one. You can see ICAO LAB Director Michael Gill and me speaking in a session. Michael, what happened to us? All right, now I'm back to my main role. Please close it. Okay, so I'm going to moderate session 2, the Aviation Safety and Security. It is a relatively long session with 4 speakers. So we have decided to have 2 mini sessions with a short break in between. It's mainly because we have a number of guests from Montreal, and there is a 13-hour time difference between Montreal and Hong Kong. So sorry, I am Korean, but I work in Hong Kong, so I keep making a mistake. Sorry about that. So for the next 65 minutes, we're going to have 2 speakers. Mr. Benoit Verhagen and Captain Bae Gang-won will make their presentation, followed by Q&A session. That will have a 10-minute break. After the short break, Captain Denise Kim-dong and Mr. David Waller will make a presentation for about 40 minutes, followed by another Q&A session. So Benoit is our first speaker. Let me briefly introduce Benoit. Detailed of CCV is on our website. Benoit is Senior External Relations and Legal Officer in ICAO LEB. He joined ICAO in 1993. His work at ICAO LEB includes legal aspect of international air navigation, ADB representative in the ICAO Air Navigation Commission, and ICAO Safety Oversight Auditor. His topic today is Global Legal Framework Serving Aviation Safety Over 80 Years. Please welcome Bina Verhegan.
Excellencies, Secretary General, dear colleagues and participants, good afternoon to all. It's really a pleasure to be here. For my part, this is the second time I attend the legal seminar. I was here in 2018, and it's always a pleasure to be in Korea. And I would like, of course, first to thank very much Molit for the wonderful organization of this seminar, and the Incheon Airport Company for the lunch, the excellent lunch we just had. Thank you, Professor Lee, for your nice introduction. What I would like to do today is to take you along on an international flight and cover the essentials that will make a trip safe in terms of responsibilities. It was a very simple question. Who is responsible for which applicable laws and regulations and where? So we'll go through this outline with you, starting with the Chicago Convention that confirmed the sovereignty principle, look at the limitations to this principle for the sake of safety. We'll address the different technical publications of ICAO and their legal status, which will lead us to the air navigation plan and the amendment process of the regional plans. And finally, we'll look at the certification licensing of the users, mainly the aircraft, the crew, and the operators. Finally, we'll reach some conclusions in terms of responsibilities. The Convention of 7744 is the result of a general agreement on the basic principle and institutional solutions for civil aviation worldwide after the Second World War. But at the same time, it is the result of a major disagreement on the issue of traffic rights, as the principle of sovereignty remained and prevailed. Indeed, Article 1 of the Convention declares that each state has complete and exclusive sovereignty over the airspace above its territory, while Article 2 states that the territory of a state consists of its land areas and territorial waters. Article 12 refers to the high seas. This means, very simply, that all waters beyond territorial waters are high seas, and the airspace above its international airspace from an aviation viewpoint. The UN Convention on the Law of the Sea, UNCLOS, of 1982 confirmed that territorial waters extend up to 12 nautical miles and that there is freedom of overflight beyond. That means that above the high seas, and including the exclusive economic zone, that extend up to 200 nautical miles. This was studied carefully by the legal committee of ICAO, which concluded in 1994 that as such, the Law of the Sea Convention was fully compatible with the Chicago Convention. So I have found on the internet this sketch that is illustrating very well this concept. While you may have under the Law of the Sea Convention several zones for maritime purposes, it remains that for the airspace, there are only two zones that are the national airspace, the sovereign airspace, up to 12 nautical miles, and after which we have entirely international airspace having the status of high seas. There are not so many exceptions to sovereignty in the Chicago where air transport as such is concerned, so you have a regime allowing overflights and technical stops for non-scheduled flights. Apart from that, virtually all international flights have to be carried out through authorization. Article 11 of the Convention, a fundamental provision, reinforced this principle of sovereignty, saying that the laws and the regulations of the state concerned apply on its territory to all aircraft, subject to non-discrimination. However, this sovereignty principle is further subject to the provisions of the Convention. Indeed, the right of state parties to the Convention to regulate air navigation over their territory is not absolute, as specific limitations concern principally safety. So Chicago may not have been a great success from an economic viewpoint, but it was a real achievement from a technical and safety viewpoint. And this is expressly reflected in several provisions of the Convention that you see on the screen, in particular the preamble and Article 44. To this end, limitations on sovereignty include the commitment of states to comply with what is called international regulations. You can find several examples in the Convention. I will refer to two at this stage. Article 12 on rules of the air stipulates that each state undertakes to maintain its own regulation in this field uniform with those established under the Convention. And Article 28 refers to the obligation of states to provide air navigation services in accordance with the standards and recommended practices established under the Convention. Such international standards and recommended practices, that we call SAPs, are adopted by the ICAO Council and placed in the annexes to the Convention. We have currently 19 annexes, but it's not exhaustive. So we have this paramount provision in the Convention, Article 37, by which the contracting states undertake to work together to ensure the highest possible degree of uniformity in their regulations in complying with these SAPs. So it's time now to go through so you have here the definitions that can be found in the Assembly resolution and in the forward of annexes for international standard and recommended practices. I take the opportunity, since we referred this morning to Annex 9, that there is an exception. So if you are not aware, you will see that these definitions are the same throughout all ICAO annexes, but not for Annex 9. Annex 9 is a different definition for a standard because it was by essence a less technical annex. So the Chicago Convention itself is an instrument of public international law. That means a treaty that governs the rights and obligations of states and that is fully binding on them. For the annexes, it's different. The annexes, however, do not have the same legal status as the Convention. If full compliance with the standard proves impossible, immediate notification of a difference may be made by virtue of Article 38 of the Convention to ICAO, and ICAO will publish it. So it can be said that ICAO standards are legally binding to the extent that the state concerned has not notified a difference. And as was said by a chairman of the legal committee a few years back, if no difference is notified from a standard, it has the status of rule of law and it is fully binding on the state concerned. Recommended practice, though, in the annexes do not have the same binding force as standards, since they are not covered by Article 38. They have a lesser legal force, but like standards, they must be adopted by the Council at a 2/3 majority vote. And furthermore, the Assembly, even if recommended practices are not covered by Article 38, the Assembly nevertheless requires states to also notify ICAO of differences from recommended practices. So if you look at the forward of annexes, you will see the description of the different components of an annex. And among the SAPs adopted by Council, not only you have the paragraphs concerned, but it also includes appendices, definitions, tables, and figures. Apart from that, annex also contain guidance. guidance documents that are approved by the Council at the simple majority voting, not adopted, which are the notes in the attachments, for example. Other documents approved at simple majority by the Council include the technical instructions for the safe transport of dangerous goods by air, the PANS and the SUPs. The PANS are the procedures for air navigation services. They are not SAPs, they are not placed in annexes, but they are approved by the Council for worldwide application. They are too detailed to be subject to the procedure of Article 90. It would be too cumbersome. But the Assembly, nevertheless, wished that SAPs and PANS be both developed by the Air Navigation Commission through a very important and extensive consultation process that is applied to both types of rules. Besides the PANS, we have the SUPs, the supplementary regional procedures. They have a similar statute to the PANS in that they are approved by the Council, they are not SAPs, and they are applied only within the respective ICAO air navigation regions concerned. And then you have circulars, manuals approved by the Secretary General that contain guidance that complement SAPs and PANS. So this is a short description of the cycle for the amendment of SAPs. It takes on average 2 years. If you are not aware, there is a very interesting description of these different technical publications of ICAO that used to be found at the back cover of the annexes, and now you can find them at the back cover of the manuals, where you will have that list. We just went through it. The SAPs, the PANS, the SUPs, the manuals, and it also refers to the air navigation plans. The air navigation plans are also approved by the Council. They detail the requirements for facilities and services for international air navigation in the different ICAO air navigation regions. The ANPs, they form the bridge between the global ICAO provisions, meaning the SAPs and the PANS, on the one hand, and the national plans of states and their implementation on the other, given the obligation of the states under Article 28 to provide such air navigation services for international traffic. And the link between the two are the SUPs. The SUPs actually form the procedural part of the air navigation plans. In this context, Annex 11 refers about air traffic services, refers to flight information regions, the FIRs, which delimit the area for which a state is responsible for providing air traffic services, or ATS. Such FIRs may therefore include sovereign airspace, but also high seas airspace. So the NPs are therefore divided into FIRs, each of them being managed by a competent ATS authority designated by the state responsible for ATS in the airspace concerned. So here you have a general map on the different ICAO region and the division of each region into FIRs. So this is the map of the region here. You see in the center Republic of Korea, the FIR Incheon, and the surrounding FIRs. The Assembly, through Resolution A4110, Appendix G, that is entitled The Delimitation of Air Traffic Services Airspace, establishes the 7 cardinal principles that govern ICAO air navigation planning. I will highlight a few of them. The first one, the limits of ATS airspaces, under sovereignty or not, shall be established exclusively on the basis of technical and operational considerations for the sake of safety, efficiency, and economy. Second principle, ATS airspaces should not be segmented or fragmented for other reasons. You will see at the number 6, the delegation of responsibility by a state to another for providing air traffic services over its territory is done without any derogation of sovereignty. And last, the Council approval for the provision by a state of ATS over the high seas does not imply any recognition of sovereignty of that state over the international airspace. So you will see that the Assembly wished to remain as remote as possible from sovereignty issues, and accordingly, you will note that the FIRs are usually named after cities, but not after states, exactly to stay away from connotation of sovereignty when dealing with air navigation planning. Let's go through the amendment process of the plans. The NPs are a compendium of the responsibilities assigned to states for the provision of air navigation facilities and services in a given area, pursuant to Article 28 and in accordance with regional air navigation agreements. The aim of ENPs, approved by the Council, is to ensure that the facilities and services provided by a state keep forming an integrated system with those of other states, which may necessitate sometimes an update and amendments. Such potential amendments are first considered by the IQ regional planning and implementation groups. You certainly heard about the PERGs. Thereafter, the amendments or the proposal for amendments to NPs are usually undertaken by correspondence between IQ and member states as coordinated by the IQ regional office concerned. And I've seen this morning that Mr. Tao Ma, the regional director at the Bangkok regional office for Asia Pacific, was here and is therefore the person responsible for this region to coordinate any amendment to the Asia Pacific Air Navigation Plan. There is a formal ANP amendment procedure that has been approved by the Council in 2014. It stipulates that a state or a group of states in a region may make a proposal to the Secretary General to be submitted through the pertinent regional office. It must be duly documented, including all the facts leading to the conclusion that an amendment is necessary, and the proposal is then circulated, analyzed by the Secretariat. In the event of a consensus, the President of the Council will give its approval to the amendment. However, should there be an objection, if no consensus can be reached while the proposal is maintained by the proposers, it will be sent to the Air Navigation Commission, which will present a technical report to the Council. And on the basis of that technical report, the Council will make its decision on the allocation of responsibility for the provision of ATS services in the area concerned. As regards the high seas, the cardinal principle of the Assembly is echoed in Annex 11 at paragraph 212. Those portions of the airspace over the high seas or airspace of undetermined sovereignty, which, by the way, refers to Antarctica, where air traffic services will be provided, shall be determined only on the basis of the regional air navigation agreements. Of course, because Article 28 deals only with sovereign airspace and the obligation of states for their territory. That means what? That means that it's quite unique. The IQ Council has an exclusive jurisdiction to make these decisions over the international airspace. It is the only legal entity that has such ultimate authority for air traffic over the high seas. With respect to national airspace, the state will nevertheless keep its ultimate sovereignty. In this regard, paragraph 211 of Annex 11 echoes another Assembly principle. By agreement, a state may delegate to another the provision of air traffic services. And of course, a note under this provision refers to the possible withdrawal of such delegation, but in good order, it is expected that it will be made through due consultation to have a smooth transition. We had in 2015 an example illustrating such principles. The national airspace of 2 states used to be within the FIR managed by the ATS authority of a 3rd neighboring state. However, the 2 states wished to withdraw their delegation of authority for the ATS and establish their own FIRs. But discussion showed that it was not pertinent to establish FIRs just for these 2 states. And they did not pursue the amendment process to establish the said FIRs. But nevertheless, they didn't want to stay in the FIR of the 3rd state, and they wished to keep the territorial airspace outside of the initial FIR. There is therefore a sectorization of the airspace within the FIR. So it's like 2 little islands within a big FIR, airspace of which is not governed by the ATS authority in charge of that FIR. The states concerned wish to keep their own sovereign authority over their exclusive sovereign airspace. So this shows that not every airspace would necessarily be actually covered by an FIR. And by the way, the audio round, we also have a case where west of Ecuador, we have a portion of high seas that has not been assigned to any authority. And therefore, we have unassigned airspace over the high seas at that place. But to continue with the example I just gave about these 2 states. So they wish to be their own master for their own territory. Fair enough, they are sovereign. And they initially considered extending their sovereign airspace up to the end of the exclusive economic zone of 200 nautical miles. We had very serious discussions with the state, and finally they had to acknowledge that airspace beyond the territorial waters of 12 nautical miles are indeed international, without any sovereignty, and that airspace over the high seas in the initial FIR remained untouched as approved by the ICAO Assembly. We had in 2021 another example that offered an interesting development. A state wished to withdraw its delegation of responsibility for ATS to a neighboring state and proposed an ENP amendment to establish its own FIR. As there was an objection, the ANC was seized, the Navigation Commission of IQ was seized of the matter. Eventually, it became clear that there was a lack of certainty on the required contents of the technical report to be submitted by the ANC to the Council. And the Council procedure was silent about it, actually. It referred to the report, but not saying what should be its contents. Therefore, the ANC established a group supported by the Secretariat, which in 2023 developed a procedure through checklist to ensure that future reports of the ANC fully meet the requirements of the Assembly in Appendix G of Resolution E4110, to ensure that the reports fully address and duly address only technical operational issues for safety, efficiency, and economy reasons. So now that we have a geographical idea of who is responsible for what in the airspaces, let's look at the users of the airspace, namely the aircraft, the crew, and the operators. The concept of aircraft registration implies the responsibility of the state of registry for the safe operation of aircraft. In particular, the state of registry is responsible for the radio licenses, the airworthiness of the aircraft, and the crew licenses. So the state of registry will issue the certificate of airworthiness and the crew licenses. For the operations, the international aircraft operations are governed by annexes to the convention, which refers to the state of the operator as being the state where the operator has its principal place of business or residence. And in case of commercial operations, the state of the operator has to issue an air operator certificate, an AOC, and operating specifications to certify an airline's ability to operate its aircraft safely during international operations. Now, we spoke about the standards and the possibility of filing a difference. So if the conditions of issuance of a certificate of airworthiness or pilot licenses do not fully comply with the standards in Annex 1 and 8, the state of registry has to comply with 3 obligations. First, notify the difference to ICAO. Second, endorse the license or the certificate, meaning making an annotation on the documents about the difference concerned. And third, the operator has to ensure that the crew and the aircraft concerned would seek overflight authorization from other states because the requirements of the annex will not be met. While over the territory, like over the high seas, the state of registry and the state of the operator, they keep their own authority, it's important to know that the differences are not exportable. For an aircraft pilots, operators they must comply with the local aviation regulations. That is what is said in Article 11 and 12 of the conventions. The state having sovereignty establishes and applies its own laws and regulations. I think that's the wrong button, sorry. Annex 6 further stipulates that before flying, pilots must be familiar with the laws and regulations in force in the areas they have to traverse. And it is true that in foreign airspace, the standards could be complied with or be deferred to, but they can be deferred to by less stringent or more stringent. To note that the standard is the average situation. If a state decides to have much more stringent requirements, that becomes a difference. For example, if in the state concerned, the pilot can never be more than 50 years old, it will be a difference from the standard that say can be up to 60 years old. So that would be a difference. To ensure smooth international navigation while preserving safety, there is, however, a magic provision that is Article 33. Article 33 to me is really a splendid creation of the Chicago Convention. It provides that states are obliged to mutually recognize the validity of foreign airworthiness certificates and crew licenses when they fully meet the minimum standards in Annex 1 and 8, even if their own national legislation would provide for more stringent requirements. I gave the example of the pilot. Even if the law says in the state pilots cannot be more than 50, if the foreign aircraft coming with a pilot that is complying in his license with Annex 1 and is 60 as per the ICAO standard, and the state that has a legislation about 50 years old maximum is obliged to let the aircraft come in and cannot prevent the pilot from flying. And we have exactly the same mechanism when we were asked about the air operator certificate. The Air Navigation Bureau colleagues, they came to us saying there was an issue about the mutual recognition of AOC. And of course, the Chicago Convention at the time of its drafters could not anticipate the concept of state of the operator and AOC. Therefore, what we did is that we just translated the same terminology as Article 33 within the standard that is now placed in Annex 6. So if a state has not filed a difference to that standard, the state is obliged, like the mechanism of Article 33, to recognize the validity for an AOC and operation specifications that are complying with the requirements of Annex 6, even if the national legislation is more stringent. So coming to the conclusions, I'd like to have a rapid overview of the responsibilities of the key players in respect of international air navigation. First, of course, the state having sovereignty. We went through Article 11, the limitations for the sake of safety, and I just spoke about the recognition of AOC and of the certificate of airworthiness and so on. How would a state verify that? For verification purposes, there are several means. First, we have Article 16 of the convention that provides the states have the right to search aircraft to inspect any documents to be on board. You, as a source of information, the state and the inspectors also have the published differences that can be found on the ICAO EFOD system, accessible to all states. Third source, you have the aeronautical information publications. And in this regard, the Assembly and Annex 15 stipulate that states shall publish their differences from SAPs and PANs in their AIP, those that are significant for safety. A fourth source of information is the ICAO auditing report, including the publication of any significant safety concerns. You also have Council resolutions or Assembly resolutions, like the Assembly in 2022 adopted two resolutions condemning the Russian Federation for infractions of the convention and the Democratic People Republic of Korea for the launching of unannounced missile launches. What is important to note is that the Assembly realized, the community realized during its 36th session that states were very keen on observing safety oversight-related obligations, but they were, let's say, less observant of their obligation under Article 11 and 12 to effect surveillance on foreign aircraft. So that is a reminder that was placed in Resolution 36.6 that is quite important and that addresses this matter in quite details if you're interested. Another key player is the state, of course, that provides air traffic services. They are provided over a sovereign territory by virtue of the national laws and regulations. We have seen that. In accordance with Article 28. And by the way, if there is delegation of authority to provide air traffic services on another state, the laws of that other state will apply over its territory. So the laws that are applicable are always those of the territory concerned, even if there was delegation of authority for the provision of ATS services. Which are they? The applicable laws and regulations stem from Annex 2 and Annex 11, but the implementation differs over the high seas. For Annex 2, it's very clear. The Council said the standards of Annex 2 are rules of the air. They fully apply over the high seas, no differences. It's different for Annex 11. The Council said in Annex 11 that a state providing ATS can implement Annex 11 in the same way throughout the FIR, be it over the sovereign airspace or the international airspace. But over international airspace, the fundamental principle remains. A state has always to ensure there is freedom of overflight. I will finish here with the state that establish air defense identification zones. There are a few in this region. Just to mention that it's not common. We maybe have like 20 of these ADs in the world. But what is very important to remember is that the procedures in accordance with guidance offered by ICAO must be limited to providing a flight plan, and especially the procedures should not be inconsistent with the ATS procedures of the airspace concerned. It is not said clearly like that, but even if it's not legally forbidden, it is safety-wise much better to avoid establishing an ADIS that would extend over the FIR of another state. And that you will see more details in this manual on civil-military cooperation. Now, the IQ is a player. You have, of course, the assembly. What I'd like to say about the assembly is that we always say the assembly resolutions are not binding on states. They are of persuasive moral value, for the most. But I'd like to insist on one thing. Assembly resolutions are binding on the IQ organs. They are binding on the Secretariat, the Secretary General, the Council, the Air Navigation Commission, which means what? When there is, for example, a proposal for amending an air navigation plan, states will make their proposals. At the end, the Air Navigation Commission in its technical report and the Council in its decision would be obliged to fully abide by the terms of Assembly Resolution 4110, Appendix G. So they will be obliged to consider only the technical safety operational aspects for economy reasons. So no politics, in principle. The President, I'd like also insist on one thing. The President, when there are no objections, he approves the ENPs, but he has a very important role when there is a problem that could be meteorological events, there could be conflicts with, use of ammunition, of all kinds of arms, that would require a deviation, a temporary deviation of the air navigation plans. So Annex 11, if you're interested, is paragraph 232, allows the President to approve contingency plans as temporary deviations from the NP until services are re-established, and this is made through consultation. For example, when we had the Libyan war, we were unable to be in contact with Tripoli FIR for the provision of air traffic information over the Tripoli FIR. So we couldn't get hold of the ATS authority, so we asked Malta, through a decision of the President of the Council, to provide such services on behalf of Tripoli FIR during the events. And last, of course, the Secretariat were here to support the IQ organs and to provide guidance to states, to train, and to be, of course, at the service of all of member states. We are civil servants who are here to serve our community. At the end, I'd like just, it's personal selection, but a few milestones. We celebrate the 80th anniversary of the Chicago Convention. I picked a few key dates as far as I'm concerned. So in 1948, the Council decided the rules of the air are those in Annex 2. Michael Gill spoke about the amendments, the fundamental amendments to the Convention, Article 82 bis and 3 bis. Believe it or not, the AOC was invented only in 1990, even if the concept of state of the operator was already there when Article 82 bis, of course, was adopted in 1980. But we had to wait another 10 years to have the concept of AOC being placed in Annex 6. 3211 is the Assembly resolution that established the Safety Oversight Program. Very important, and I'd like to have a little word from my colleague Armando Quiros that deceased last week. I was very privileged to work with him. We drafted together Assembly Resolution 3211. So I have very fond memories of our work. At the time we realized it was a very important step in ICAO's life. What is interesting is that sovereignty, you remember we spoke about the principle of sovereignty. We could not just arrive in a state and audit a state. We had to respect its sovereignty. So what we did is that we placed in the Assembly resolution a requirement for the audit to take place under the signature of a memorandum of understanding, by which the state would relinquish part of its sovereignty and allow ICAO to make audits and eventually to publish the results. 2001, to me also a key date. It was not easy because the French in particular were not very happy. They were, of course, and we all sympathize with that, in favor of multilingualism. But we realized during the audits that this was essential for inspectors to be able to have a common language in order to validly review licenses and certificates on board, meaning that all principal safety documents on board, if not issued in English, should have a translation into English. And that improved a lot the way inspectors could abide by their duties. 2001, of course, there was the 9/11.
Sorry, Benoit.
Yes, I finished. 1 minute left? Okay. So the 9/11, it was important, is where the Assembly said, okay, you have to effect consultation to prepare amendments to SAPs and PANs, but not if there is a real urgency. And the urgency was applied for the cockpit doors for an amendment to Annex 17. Annex 19 in 2013 was the creation of this annex devoted only to safety management. And I will finish with 2017, just to speak for my own shop and for the Secretariat. The manual on the implementation of Article 83 bis, it was a joint effort of Air Navigation Bureau and Legal Bureau. I think it was the first ever we had this kind of joint efforts. And even if it speaks about Article 83 bis, go through it. It reviews a lot of safety-related aspects of the convention. It's Article 30, Article 31, Article 32, and so on. So I wish to thank you very much for your attention. And I wish again to say thank you so much to Molit for organizing this seminar. Thank you.
Thank you, Benoit, for your comprehensive presentation. Also, thank you for your on-time performance. It was not easy to cover so many different and important aspects of aviation safety within those short period of time. Thank you. So our next speaker, before we have a break, so as a moderator, I'll be very strict on coffee break. So I'll make sure we have a coffee break, 2:10. But before we have a coffee break, we are going to have our second speaker, Captain Bae Kang-won. Captain Bae is a director of aviation investigation team in Korean Air. In Korean Air, he has held various leadership roles, including director of corporate safety and security investigation, flight operation quality teams. His topic today is common issues in aviation safety and security in implementation of legal framework. Captain Bae, the floor is yours.
Time-wise, it's a very critical time. It's coming to the 2 o'clock, and as our moderator, Professor Lee said, our body also needs some of the waking up call for the coffee. So I'd like to make a pace a little bit faster. So if you think it's too fast, give me some tips, then I can slow down maybe a little bit, okay? Your Excellencies and then all the distinguished guests and ladies and gentlemen, good to see you all. My name is Kang-won Bae, as introduced, and I'm Korean Air Airbus 330 captain, and I'm also working as a director of the corporate safety. And it's a great pleasure to participate and honor to be invited as speaker, and for such an important ICAO seminar. As you can see, this is me. And today, I'm going to talk about the common issues in aviation safety and security implication and legal framework. And in preparation, I've had many valuable opportunity to meet up those safety and security experts and legal professionals. And aviation safety, as you know, and security is interdependent, it's connected concepts. By understanding and nurturing this relationship, we can create a safer and more secure sky for everyone. And today's focus is on aviation safety and security, with a particular emphasis on how serious injury. You may heard of it a lot. Serious injury are defined in aviation accident investigation. And whilst there are fatal cases of the accidents, it's very easy to and then very straightforward to address. But on the other hand, some of the cases in the serious injury can present some ambiguity during investigation. Sorry, it's moving on. And the clear definition of the serious injury is crucial for the objectively assessing the accident severity and determining liability, and fostering international cooperation on safety standards. This will be key focus on my presentation. And please take a look at the picture on the screen here. And isn't it familiar scene nowadays? You may have seen this kind of picture or on TV news and the media. And nowadays, very often than not, we see this turbulence-related news. And it's even get some of the fear of flying. Myself, I'm a captain, but when I have this kind of news, I always have some fear. One of the ongoing challenges in aviation safety is managing the risk of in-flight turbulence and the potential injury it can cause. And especially the cabin crew. As you can see on the left side of the corner, the ladies, that's a cabin crew of the flight. And these people particularly face a very difficult situation during turbulence. While a safety protocol requires them to be secure themselves and be seated, but they have other duty to protect, and they are responsible to protect their passenger at the same time in the such events. Balancing these kind of priorities is very crucial, especially since cabin crews are often at the risk of injury in turbulence conditions. And I want to show you the data released by the Flight Safe Foundation, year 2023 safety report just released last month. And it suggested that in-flight injury are the most frequent type of aviation accident recent year, particularly over the past 5 years. And the table included in the report, as you can see, indeed, the turbulence is the leading cause of in-flight injury of aviation accident, followed by the runway excursion. And interestingly, recent studies by meteorology experts suggested that the possible connection with the global weather pattern changes and with increase of this kind of injuries. And coming to the main topic here, the serious definition in the ICAO Act 13 is crucial for classifying aviation events. This international standard provides a framework for the investigating accidents and incidents to identify their cause and prevent further future occurrences. And clear interpretation of the benefit, airlines and authority and all stakeholders. And ICAO Act 13 is first adopted in 1951 and has undergone 12 amendments to reflect the revolving environmental considerations and technological advancements and the reality of the daily operations. However, one area where further discussion may be beneficial is the definition of serious injury. While this definition was amended directly to that provision directly in 1988, in Amendment 7, the pace of the technological change and evolving societal value may warrant further exploration. And as you can see on the screen, this is the definition of the serious injury in the Annex 13. I do not want to go to read all the detail, but I believe there's some consideration in the industry for the potential for improvement. The current definition of the serious injury might benefit from the improvement to ensure objective assessment, facilitate international comparison, and enhance safety data analysis. This could involve exploring medical expertise for evaluating and standardizing the definition across the country. By fostering this discussion, the international aviation community can work towards continuously strengthening the effectiveness of ICAO Annex 13 for the benefit of aviation worldwide. Sorry. And it is also very interesting to consider how other transportation sector approach the definition of the serious injury. For example, as you can see on the screen here, the European Commission has established a detailed definition that incorporates scientific and medical consideration. This level of detail reflects the importance of a clear and objective definition in a field where legal implications and responsibility can be significant. And this is the US Department of Transportation standard of serious injury with an in-depth research result. And they are fostering and try to embrace more medical expertise, and extensive study have been applied to their formula. They using a formula of definition of serious injury. And interestingly, this is a Chinese letter language, and this is the Chinese criminal law reference of definition of serious injury with a very detailed and thorough full document to apply their transportation-related injury. And while this definition may not directly apply to the civil aviation safety investigation, it offers valuable insight into the legal considerations surrounding injury classification. And I just added some of the English version of this document for your reference. Later on, you take a look at the material, my presentation material. And it's interesting to see how other transportation sector and legal system approach the definition of serious injury. And many incorporate the scientific, as I said, medical consideration, resulting in a detailed and evolving definition. And this ongoing process of refinement ensure that these definitions remain relevant and effective. While ICAO 13 provides a valuable framework for aviation safety investigation, perhaps exploring similar approaches to defining serious injury as other transportation does could be beneficial. And by fostering discussion and incorporating more objective criteria and potentially considering periodic review. This is another important word, potentially periodic review. We can work towards a definition that better reflects the current medical understanding and serves the best interest of the aviation safety. And now let me tell you some of the different aspects. Principle of legal interpretation. Principle of legal interpretation. I'm not intending to bring you back to the law school freshman classroom. But the law contains certain corresponding facts and the ideology of the social life in it, which are expressed in the words of the provisions. Therefore, the interpretation of the law begins with a literal and logical interpretation of the linguistic meaning of the provision, but requires a purposeful consideration. A competent interpretation is an interpretation based on the authority given to the state agency. Judicial interpretation is normally most common form of the interpretation by courts, whose task is to apply the law. But the administrative interpretation immediately affects the case immensely, and it is accepted as a legal effect as long as it is challenged by the administrative or legal procedure, which takes a long time. Administrative interpretation serves a practical code of conduct until a court of ruling is made, where when there is an administrative interpretation from a competent ministry, citizens tend to act based on it, unless there's a special circumstances. The definition of the serious injury again, some discussion about whether the provision in Annex 13 within the definition of serious injury, typically article the Bravo, result in a fracture of any bones except simple fracture of fingers, toes, and nose. Is it enumerative, or illustrative? You may have heard the terms enumerative or illustrative. I compare a little bit of difference with the ICAO definition and the Korean safety law. It's seemingly a little bit different. And enumerative provision typically lists a specific example, while illustrative provision offer example to clarify the broader concepts. Understanding the intent behind this specific provision could be helpful in ensuring a consistent interpretation. Perhaps we could delve deeper into the relevant legal context and overall purpose of the definition to determine the most appropriate interpretation. Defining serious injury with the aviation safety and security can be a complex task, while universally perfect definitions may be almost improbable. Additionally, safety professionals may not always have access to complete medical information, which can introduce elements of uncertainty. And furthermore, individual factors like recovery timelines can vary significantly. This complexity highlights the importance of an ongoing discussion on how to best define serious injury within the aviation safety framework. By acknowledging these challenges and fostering collaboration with medical professionals and legal experts, we can strive towards a definition that is more objective, reflects current medical understanding, and ultimately serves the best interest of aviation safety. As an ongoing effort, Korean Air, these concerns regarding clarifying the definition have been addressed in international conferences with lots of consensus of participants, such as FlySafe Foundation International Aviation Safety Summit year 2023 in Paris, and ICAO Regional Aviation Safety Group Pan America, RASPA, in Santo Domingo year 2023. And specifically, these concerns were delivered to the ICAO AIG, Accident Investigation Group sector directly, and I was informed that this will be introduced to the panel group discussion. There is some process to discuss. To recap two key points that I present today, the definition of the serious injury within ICAO Annex 13 is a critical element, is aviation safety investigation, and plays a vital role in preventing accidents. However, there's some room for improvement. We've explored some of the potential area of the consideration, such as defining the definition to enhance clarity and consistency, and providing further clarification on the interpretation of the specific example, such as fractures, and developing additional guidance for the administrative interpretation. And there are several steps that we can take to address these challenges associated with the current definition of serious injury. We need to establish clear and specific criteria for what constitutes a serious injury, typically considering medical expertise, I would say. And additionally, ICAO-centered international collaboration is crucial to develop the globally accepted definitions. And finally, we would continuously evaluate the effectiveness of the definition and make adjustments as needed to ensure its continued relevance in promoting aviation safety. That is the nature of the law regulating nature. And reality changes, it should draw regulation change. In conclusion, overall conclusion, clarifying definition of serious injury is essential for protecting the lives of passengers and crews, and even sustainability of the aviation itself. And clear and harmonized definition of the serious injury are needed now at the national and international levels. Continuous efforts and cooperation are required to strengthen safety and security measures to prevent serious injury in aviation. That makes aviation even safer. And ladies and gentlemen, this concludes my presentation, and I want to express my gratitude for your attention today. And let's continue to work, help each other, to share the knowledge and value. And lastly, it's just such a privilege again, to participate in this kind of important seminar, and I look forward to working together in future. Thank you very much indeed, and wish you have a great afternoon. Thank you very much.
Thank you, Captain Bae. So as promised, we are going to have a coffee break for 10 minutes. Remember, we have another coffee break, so make it quick. So in 10 minutes, I will see you later. Thank you.
Yes, welcome back everyone. We are to resume our second session on aviation safety and security here at 2024 ICAO Legal Seminar Day 1. We have listened to the presentation brought by Mr. Venua Verhagen and also Mr. Kang Won Bae. And we have two more presenters to go, and afterwards we'll be moving on with our discussions. So if you have any questions, please hold them until the end of the session. And I will now pass on the mic once again to our moderator, Professor Lee.
Thank you. Welcome back, everyone. So for the next 55 minutes, we will discuss role of regional safety oversight organization in supporting states. So we have two speakers with that topic. I will also make sure that we have a Q&A session at the end of this session too. So our third speaker is Captain Denise Gaindong. Captain Gaindong is Deputy Director of Monitoring, Analysis, and Coordination in ICAO Air Navigation Bureau. Captain Gaindong joined ICAO in 2018, and after a long career at Transport Canada Civil Aviation, where he was Director General of Civil Aviation. At ICAO ANB, he oversees all continuous monitoring and oversight activity. Captain, the floor is yours.
Good afternoon, Vice Minister Beck, Secretary General, Director General of Civil Aviation, distinguished guests and colleagues. As you are well aware, supporting the function of a CA is complex in the area and as well financially demanding for several states. For the last 30 years, some states are grouping themselves to try to improve their capacity and efficiencies in discharging their safety obligation by combining resources. We call them RSOs. The Interstate Aviation Committee, commonly known as AIC, first RSO and was established in 1991 and included 12 of the former Soviet Union member states. The number of RSOs since and their sister regional accident investigation organization, what we call the RAIOs, have continued to grow and are now supporting more and more states. RSOs are well recognized, and as such, ICAO Assembly Resolution A40-6 states in part, recalling the member states are responsible for implementing ICAO standards and may, in this respect, decide on a voluntary basis to delegate certain functions to RSOs, and that, when applicable, the world state should be read to include RSOs. But obviously, RSOs are not all created equal and have different structure, governance mechanism, and obviously some are more complex and offer more service than others. There are a multitude of RSOs, and they are listed in alphabetical order on this slide and the next two slides. You will see they cover many areas of the world, but are more concentrated where there is needs to support actively states which are challenged with resource and capacity. We have as well other which are covering well-developed aviation systems and perform complex activities. 6 are covering Africa. AXA covers Central America. We have EASA that covers European Union and is the most mature organization and offer a suite of complex services. The Interstate Aviation Community, which was discussed earlier at the beginning of the presentation, offers safety but as well investigation services. CASOS covers part of the Caribbean. PASO covers a very much needed support for several small Pacific states. Additionally, and finally, we have the just formed RSO MENA that was created a few months ago in Saudi Arabia. The organization will be based in the UAE and covers several states from the Maghreb and as well Eastern Africa and the Middle East. ICAO is establishing contact with them at present, so to bring them along in our cooperative platforms. Currently, close to 130 states are members of an RSO, as shown on the map above. The map does not show MENA coming to life, but its formation now almost all of African states are covered by supportive RSO, which is very positive. Regional cooperation is not only in safety oversight, but as well have specialized organization in incident and accident investigation, which are called RAIOs. 5 of such organizations exist, which cover part of South America. There is one in Banjul Accord Group named Bagaya, one in Europe in Cassia, and finally IAC in Russia. So far, a total 64 states under the support of an RAIO. So just back to this slide to show you what we have around the world right now at present, and it's still evolving. So why an RSO? Some states may have less than ideal oversight capabilities, difficulty providing financial or human resources, lack of qualified personnel, difficulty ensuring competency of their technical staff, low level of activity to warrant full-time personnel attached to the civil aviation organization, or some states has capacity to leverage their expertise and resources to support their neighbor states and effectively improve aviation safety on transborder flights transporting their citizens. A good example of this in the Pacific is New Zealand that is supporting PASO. The defining characteristics that are common to all RSOs lie in their uniform mandate, objective, and purpose. Low level of activities coupled with competing demands for state resources may result in inadequate allocation of resource for a state aviation safety oversight or investigative activities and program. Additionally, innovation and emergence of new industry entrants, new technology also require additional resources and expertise which may not be readily available within the states can be provided by an RSO. The function being conducted by RSOs have grown from advisory or coordination to surveillance and even certification. ICAO has defined 3 levels of RSOs as such. Level 1, RSO provides advisory and coordination functions such as advising states with regulation, development of guidance material, and coordinating pools of expert or inspectors. Level 2 RSOs provide operational assistance functions such as developing regulation, training inspectors, and conducting inspection or investigation. RSOs such as AXA in Central America or Bagasso in West Africa do this. Level 3 RSOs includes level 2 function plus certifying function, issuance of regulation, and authority to issue, amend or revoke licenses, authorizations, and approvals. For example, EASA and IAC. These last 2 are the most complex RSOs we have. There are several reasons states may join or form an RSO. However, the most common reason is to assist in effective safety oversight. RSOs can provide expert advisory and consultative service for effective safety oversight. They share best practices. They issue technical assistance. They execute safety oversight function on behalf of member states. As well, they can support or provide a level playing field between certificate holders of different countries by promoting a common set of aviation safety requirements, oversight, and standardized application of rules. During the first few weeks of the COVID-19 pandemic, we saw RSOs coordinate their member states' response on differences, implementation of harmonized measures to mitigate the effect of the COVID-19 pandemic, and maintain the safety performance at regional and global levels. Additionally, RSOs assist states in preparation of USOP audits, but most importantly, assist their state on correction of SSCs and deficiencies. Furthermore, some RSOs have developed cooperative inspectorate schemes where qualified regional inspectors are used in a pool of inspectors within the region. In regard to funding of RSOs, funding source may include member states and regional economic communities' contribution, donation, and or grants from international donor organizations. Specific user fees and charge ultimately through the collection of an air safety charge. For example, 3 states, Gambia, Ghana, and Sierra Leone, out of the 7 Bagasso member states have adopted the safety charge in their legislation, out of which 1 state, Ghana, has implemented. Guinea, Liberia, and Sierra Leone live by charge through their flight information region, their FIR. At ICAO, the Regional Safety Cooperation Unit facilitates regional cooperation through 4 areas. First, the cooperative platform brings together about 14 RSOs and 5 RAIOs and investigation cooperation mechanism to strengthen them, share best practices, and build partnership. Second, we are working actively on the voluntary assessment program of RSOs and RSIOs, which assess qualification capability using tools similar to those of the USOP program. The program right now is going through substantive change from GASOS to the RSOs, RAIOs assessment program called RRAP. We're about to publish the newly amended 3rd edition of the manual Doc 9734 Part B, the establishment and management of a regional safety oversight organization, due to results of studies conducted and development since the last edition that was published in 2011. The first edition of the RSOs and RAIO assessment program, the RAP Manual Doc 10143, is being developed at present. Under communication and training, the last area, we provide training, workshop, safety promotion of RSOs, present papers, and conduct studies on RSOs, RAIOs, and have held international conference on RSOs, such as the virtual ICAO EASA Strengthening Regional Cooperation Conference in 2022, and the recently completed 2nd RSO Forum in Nairobi in October 2023. In more details of those 4 areas, RSO cooperative platform core functions are to assist and strengthen RSOs, and the platform carries this with an exchange of information and best practices, coordination and sharing of manuals, communication and ID exchange, networking, but as well, and very importantly, a byproduct of the RSO cooperative platform is a feedback loop to ICAO on its program, needed improvement on implementation strategies, guidance material, and etc. In regard to the evolution of GASOS to the RSO RAIO's assessment program, some of you can probably recall that the global the global strategy for GASOS was adopted at the RSO forum in Eswatini in 2017. A year later, in 2018, the ENG Conference 13 limited GASOS to RSOs, RAIOs, and to assess RSOs and RAIOs at level 1 and 2 only. The level 3 organizations, such as EASA, are under the evaluation of the USOP, since some of the service of this organization are at the level and scope of a state. In 2019, the 40th Assembly endorsed the GASOS program after it was approved by the Council, and in 2024, the GASOS scope was changed and renamed RRAP. For the RAP, which is an important transformation from the initial vision of GASOS, it is now a voluntary program and not an audit. It uses modified USOP tools and its proven methodology. It is under a cost recovery mechanism, and it assesses capabilities, provides an assessment core, identifies gaps, and finally suggests improvement to the organization. For guidance material, we see different levels of maturity in RSO, obviously, from organization with 20, 30 years of experience to the recently established RSOs or other mechanisms with different dynamics. Those asymmetries oblige us to recognize the relevance of this type of cooperation at different stages of development, so to maximize our efficiency in developing guidance material that could be applicable for newcomers, but as well for olders and more mature organizations. And a new guidance document on RAP, which was created by a group of experts and finalized within the Air Navigation Bureau, we are targeting end of 2024 for publication. And finally, on the last area, and to conclude, the support to RSOs by ICAO, the communication and training includes RSO forums, conference, workshop, training through the RSO cooperative platform, plan online training for RAP assessors, as well as updating relevant ICAO documents and policy on regional safety cooperation. And in conclusion, we obviously see the benefit of RSO as one of the pillars of implementation support that ICAO can offer. ICAO provides a safety framework toolbox which consists of SARPs, guidance material, auditing of states through the USOP, but actually, indeed, a well-organized and active support of RSOs and RSOs is a strong addition to the suite of tools ICAO offers. It provides states with less means to better achieve safety implementation of ICAO requirements, and in turn, an increase in safety level across the region and in the world. I want to thank you for your attention.
Thank you. Based on your on-time performance, I can see that you are captain. So our last speaker is Mr. David Waller. David is EASA, European Union Aviation Safety Agency, EASA representative in Singapore. He has worked for EASA, he joined EASA in 2004 and has held various positions in technical training, international cooperation, and strategy development. David is originally from Britain. So several years back, when Brexit was such a hot topic, I asked him whether he's going to be okay after Brexit at EASA. He told me I'm also Irish. So please welcome British and Irish David.
Thank you very much, June. I'm very much a fake Irishman, not a real Irishman, so I make no pretenses there. So, dear distinguished hosts, dear distinguished guests, thank you very much for having me. I think Denis gave a very good presentation on RSOOs there, so it's left to me just to kind of color in the subject with a practical example. EASA was mentioned, we are one such organization, an RSOO. But before I continue on EASA, before I say any more about RSOOs, I think it's worth taking a step back and looking at the benefits of regionalization as a whole, before we just focus on organizations that maybe can support that in terms of safety. So the benefits of regionalization don't just include safety. You can see really they affect the full spectrum of stakeholders involved. The benefits include a lot of economic, which is of course a very powerful driver for making things happen as resources are always scarce. There are clear benefits for industry, which are perhaps not really clearly mentioned enough on this slide, such as a more level playing field, more operational certainty, due to the similar rules between states, and, for example, a single approval process instead of multiple audits, cutting down on duplicated oversight. On that last point there, I don't know how much you can actually read what's in the slide on the partners. The EU, as a region, loves dialogues with other regions, particularly ASEAN, for example, and also with its fellow RSOOs. And we channel a lot of technical assistance via RSOOs. And I'll speak more about that in a second. So a bit more background. As Denis mentioned, RSOOs have been in existence for more than 30 years. And partially because of their independent evolution to each other, in other words, they evolved apart, there are various institutional setups. So for example, there's EASA with a very solid, let's say, legal basis. At maybe more the other end of the spectrum, and I'm not even sure it can be classified as an RSOO, not quite even level 1. There are organizations such as SRVSOP in South America, which don't have a specific legal personality. They operate more as an ICAO program, but support states nonetheless. But since every region is different, with different political structures and needs, I think this variety makes sense. ICAO recognized the benefits of RSOOs quite early up. So it issued, as Denis presented earlier, the Safety Oversight Manual, document 9734B in 2006. I think that should have been another one to add to the Benoit's milestone list. And that was extremely helpful because I think it helps solve something which looks like a contradiction, because the Chicago Convention considers states not really regional organizations. But the two aren't mutually exclusive or incompatible, as we'll mention in a second. So obviously being an RSOO, EASA has been very keen to work with ICAO to help drive the RSOO concept forward. You can see some forums here, some of which were mentioned earlier. The 2017 forum in Eswatini paved the way for the RSOO collaborative platform and the concept of the Global Aviation Safety Oversight System that Denis mentioned, GASOS, the assessment mechanism for regional organizations based on USOC principles. In 2019, the Assembly passed resolution A46, that's on regional cooperation and assistance to resolve safety deficiencies, establishing priorities and setting measurable targets. The 2022 virtual conference that you see mentioned there, that built on the ICAO high-level conference on COVID-19 in 2021, which also considered proposals on how to strengthen various forms of regional cooperation and proposed recommendations addressed to states and ICAO. There's the 2023 forum that Denis mentioned, which made a number of recommendations for ICAO, states, RSOs, and industry. And although not mentioned there, but it's also something EASA supports. We have some long-term secondments of experts to the ICAO Secretariat to support their work on RSOs. So now I'd like to talk about EASA, but it is an unusual RSOO. As Denis mentioned, it's level 3. It's quite advanced. But a lot of, I think, what I want to say about EASA, yes, we're kind of a special case. We have this supranational framework of the European Union to hang off. That's very useful, but it's not essential. Actually, there was a regional safety oversight organization in Europe before EASA came along, so it was the Joint Aviation Authorities. And I think that illustrates a lot of the principles that I kind of touched on earlier, because it's the motive for it, what made that happen, are in line with what I mentioned earlier. So I talked about economic drivers. Principally, it was a little bit, the pressure came from industry. Companies such as Airbus and Rolls-Royce, they didn't enjoy having to spend millions of euros on type certification of their products in every single European state. It makes much more sense to just do it once. So they created the Joint Aviation Authorities, which operated under something called the Cyprus Agreements. So Europe worked collectively together before EASA was ever born. Nonetheless, a lot of what EASA does, I'm wondering what's going on with my slides. A lot of what EASA does, so yes, we benefit from that supernatural framework, but we probably do a lot of that even if it didn't exist. For those of you who have not been to EASA, it's that building on the right there, just by the river. So we're very small, actually. I mean, I think 800 is probably a lot smaller or a lot fewer people in your respective organizations, but we have the luxury of really only focusing on safety and more recently, sustainability. So in very high level, we kind of carry out 4 tasks, which you can see in each of the corners there. And in the middle is our scope in terms of topics and themes. So certificates and approvals, EU rules, so the principle being 1 certificate, 1 approval is good for all of Europe. EU rules and guidance material, so it's 1 set of rules for all of Europe, so instant harmonization. Member state inspections, so we check to make sure that the rules are applied in the same way in each European member state. And then we also have an international cooperation function which provides support, particularly through RSOOs, as I mentioned before. So in more detail, so to use the nomenclature described by Denis earlier, a lot of what we do is at level 1, but we have this ability to carry out tasks on behalf of the member states based on the Treaty of the Functioning of the European Union. This is notified to ICAO by the member states, but it's important to point out that EASA or EU member states retain their international responsibilities as ICAO members. It's individual member states that vote in ICAO. So it's not the EU or EASA. So yeah, examples of our work, as I mentioned, certification of aeronautical products, approval of design organizations, certification of pan-European operators, like Airbus, for example, which is present across many European countries. Again, the logic is that it has to make sense to do it at regional level. Otherwise, it's done by the member states. So in fact, actually the bulk of work is done by member states, and it's only these examples where centralization makes sense that is done by EASA. This shows a lot of the other RSOOs worldwide that we support. So principally here you see Africa, Latin America, and the Caribbean. In Asia, although ASEAN is not an RSOO, we work with ASEAN to support their ambitions for regional integration under the Kuala Lumpur Transport Strategic Plan. And we similarly work with South Asia under the framework of SARC to support the South Asia Regional Initiative there. So the conundrum, how does that work within the states-orientated framework of the ICAO, the Chicago Convention? I'm not sure how readable that is, but yeah, I mean, it sets out the kind of conditions. So this refers to rendering each other's licenses valid, subject to certain provisions. And within the notes here, the text, it explains that under Note 2, for example, common licensing regulations refer to a common licensing regulatory framework that is legally binding and directly applicable to contracting party to the agreement, recognizing the automatic validation process. It carries on. A regional aviation safety body can develop and maintain these common regulations for its member states. So this amendment facilitated or facilitates the operation of RSOOs under the state-orientated framework of the Chicago Convention. Some further benefits of RSOOs, what are their advantages? So the first point there, you see that they know their states well. I guess that kind of follows the logic of the ICAO regional offices in a way which, because they're closer to their states, they know them more intimately, they're able to support them better in their setup and functioning. The second point on synergy and coordination, I think that really can't be understated. Any work lost in coordination, because sometimes coordination can be quite complex, is more than made up for the fact that now you don't have to reinvent the wheel. What's good for one state can be used by all states. The same logic is reflected in the sharing and simultaneous transmission of information. And RSOOs also allow the creation of regional systems. So yeah, examples there, ramp inspections, occurrence reporting. So if nothing else, the economy of scale, the increased sample size helps you build up a more detailed and therefore more accurate picture, improving safety intelligence. And some very last takeaways before I close. So hopefully most of these echo points I've already made. So in developing an RSOO, it has to be driven by what makes sense. It's not something you just do for the sake of it. The benefits, the economic drivers, for example, should be there to drive forward the integration. Otherwise, you won't get that political buy-in, you won't get that industry buy-in, and so forth. There's no one-size-fits-all solution. So yes, EASA or Europe, we do it one way, and we absolutely do not say, when we work with other RSOOs in the world, that's the way you should do it. Each region is different, and solutions have to be tailored to the unique specificities of each region. And lastly, and I leave it, it's last, but unfortunately, certainly not least, it is a reality. A key challenge for RSOOs that we all have to work with is the one of sustainable funding, always a key challenge. So that's it from me. Thank you very much for your attention. It was a pleasure to be able to speak to you, and I now hand back to June for the question and answer session.
Great. Thank you, David, and also thank you all the panelists for your really on-time performance so that we can have 20-minute Q&A session. So what I'm going to do is I'm going to pose some questions to each speaker, and after my questions, we also receive some questions from the floor, so be prepared. Maybe raise your hand. I mean, I'm not going to call you, but right after our discussion, we are going to take questions from the floor. So my first question to Benoit is that, so you talked about the difference between standard and recommended practice in terms of reporting. So under Article 37, 38, for standard, state need to report its departure. And you also talked about the possibility of having the reporting system on recommended practice. So I think ideally it's nice to have that reporting system, even though we don't have such law under Chicago Convention. Can you explain a little bit more about that? 1 or 2 minutes, please.
Thank you very much, June, for this question. I'm very fond of recommended practices, and I think they are neglected a bit too much, just because they don't have the same legal force as standards. But they're extremely important. They're extremely important. First, it's obvious from the fact that they are adopted by the Council. They're subject to the two-thirds adoption procedure in the Council. Why are they important? Because they are actually the preliminary stage before a requirement could become a standard. It's a test phase. And it's why it's very important to have a feedback about the implementation, because, look, imagine a recommended practice that is not followed by nobody, that nobody likes, but nobody reports about it. The reaction we may have at headquarters in Secretariat is, yeah, great, no differences filed. So it's fantastic. So let's go for an upgrade and let's go to the Council for adopting this requirement as a standard. That's why the Assembly complemented Article 38. And the Assembly decided to ask the states to consider filing differences not only from standards, but also from recommended practices. But there is a second reason. I mentioned that the Assembly also, and the Annex 15 actually, says that the states are expected to publish in their aeronautical information publications such differences from SARBs and PANs, so meaning including recommended practices, that would have a significant impact for safety. The only problem in terms of practical difficulties is that the annex does not qualify or define was it significant in terms of safety. So it's left to the discretion, to the consideration of each state. And look, in order to have a real good overview of the subject, then it's better if we can rely on the filing of differences. Thank you.
Thank you, thank you. So my question to Captain Bear. So in your presentation, you suggest that new definition of serious injury. But those who are studying aviation law, you probably know that a lot of conventions have a problem of having right definition, not only Chicago Convention on one axis. The Montreal Convention, as example, accident, bodily injury, delay. These are terms we can never have perfect definition. So my question to you is that the new your suggestion, isn't it impossible dream to have a right, perfect definition?
Thank you for the question. First of all, I'm not talking about the exact suggestion, words to words. This is the definition. We have to move on. Because as you point out, it's almost improbable to come down to the all of the definition that is related to the aviation safety. Especially today, I talked about serious injury and then the way forward, how we move up with this kind of terms and definition that I would say, I think it's a law or a nature. There's a certain process move on, which is, we call it an evolution. Serious injury part of the definition was, as I point out, was first come out into effect in 1951. And ever since, there were 12 amendments of an ICAO and 13 improvements. And then there were lots of consideration as stepping forward at these 12 amendments. But direct point to the serious injury part of the ICAO next consideration was lastly in 1988. And then as you said, then, there are environmental changes and technical changes, and then every circumstance on aviation changes. But I believe we are a little bit, maybe we made maybe from the beginning too perfect definition, I would say. But as situation changes, we have to look at it very carefully with that. And as I point out that when something changes, always there is a reason. First, if it sounds rational and reasonable and it's very plausible, that's the way we go forward. Or it is not easy. You think it is the perfect moment we have to go for. It's not easy. Practically speaking, we have to look at our neighbor, what they are doing. If they advance, they're going forward. We don't know why, but there is a reason always. And then that's the point I'm talking about. We consider a little bit carefully with our other transportation sectors, considering about their serious, because they have for example, the ground transportation, there are so many accidents and so many things considering the definition of serious injury, because it has not only the protection of those passengers and victims, but also its litigations and the cases. Okay. So we have to take a look at it very seriously.
Understood. Thanks. So question to Captain Ging-dong. I actually had a couple of questions. I mean, really, I wish I had more time. I mean, I wish I had a vending machine so I can put my coin. I can save on my time, but time is limited. So question I received from my friend, knowing that you are coming to this floor, is that how does COVID-19, it's really remarkable that we never talked about COVID-19. It's really nice that we never talked about COVID-19 in this legal seminar. But the question I going to ask is that how does COVID-19 type crisis, how can our SUS can help this kind of global crisis?
Thank you. Well, first of all, it was very exciting for all of us, obviously. It was extremely challenging. We saw a different approach and different measure being taken around the world. We saw some fantastic opportunity coming out of Europe and the Europeans through EASA trying to support actually the resume of operation in complex areas. But we had as well some states which had not very much means that were able through their RSOs actually to work through, even if they were level 1 or level 2 actually organization that were able to pull their IDs together. At the same time, what was interesting is the cooperative platform that ICAO was offering to the RSOs was coming together to try to help all those RSOs to have discussions and share best practices, tools, and at the same time to be able to be quite helpful in transmitting information and the best practices. So it was certainly highly challenging, but I think that is as with anything. I mean, cooperation between people brings better benefit and as well additional capacity to be able to support some challenges. So thank you very much.
Okay, so my final question, so again, after this session, we're going to receive questions from the floor. So if you have any question, please raise your hand. then microphone will be ready. So question to David. In the last slide, you talked about, quote unquote, you don't need supranational structure like EU to make it work. Yeah, that's what you said. So in terms of any types of regional integration in aviation, EU has been named as the best example. At the same time, we know that EU is highly exceptional. So my question to you is that what kind of lesson you can provide to those who are considering ARSUS?
I think it goes back to what I was saying about the need, a kind of needs-driven approach. Actually, I think COVID is a very good example. So EASA developed the, it was called the EASA ECDC Aviation Health Safety Protocol. We had absolutely no competence in health before that, EASA, I mean. So we had no legal basis to issue this document, which was used by many member states and turned into law by many member states, which Europe found extremely useful. Certainly European industry found very useful because in each country, suddenly there was a harmonized approach. So it was the fact that we provided a platform by which the member states could get together, could get to agree on a kind of common set of rules. Each member state knew that EASA had no legal power, or the EU had no legal power to impose that set of rules. But as it made sense, each state was happy to kind of incorporate that, digest that within its national system. So in short, where there's a will, there's a way. RSOOs, just the simple fact of providing cooperation platform between member states are extremely powerful, and harmonization and all these other benefits flow out of that as a natural consequence.
Thank you. All right, so we have about 10 minutes for Q&A. Anyone who has a question, please raise your hand.
Thank you, Mr. Moderator. I'm Soyeon Park from Mullet, and I'm looking after aviation safety data collected by reporting systems or other data collection system in Korea. And I am looking after the state safety program, so which means I am in safety management area. So I have a question to Captain Bae. Turbulence injury is actually one of the most frequent safety issues in Korea as well. Can you elaborate a little bit more on the implication or possible impact of redefining the definition of serious injuries in the context of aviation safety? Thank you.
Thank you very much, Ms. Park, and it's a very important question. As I said before, this is nowadays the weather pattern change, and it connects with lots of in-flight turbulence-related injury happens, and then international aviation safety, it's tried to address the question and how to deal with the situation. To answer your question, redefinition or clarifying the definition of serious injury is very important because, first of all, I can say philosophical reason. First, that is right to move forward because if there is no perfect definition that fits from what we are, it's not going to work. So that's number one, the philosophical answer. Number two, I would say a pragmatical answer. Ladies and gentlemen, it's the accident. I'm talking about accidents. That serious definition, draw the lines coming over, whether this becomes an accident or it's just an event or incident. When it comes to the individual operator, having a one accident, it's a big story. You never know how big burden individual operator will face with having an accident. If they have a fatal, yes, they deserve it, I would say. But let's say you have some stress fracture, then by the definition, it becomes an accident. Now it's a different story. Let's moving on to the state level. They are responsible for the maintaining their state's rate of a certain level of safety. Once an individual operator within the region of their state level, if they have a 1 or 2 accident, now it's also they are failing with their objectivity of the maintaining certain level of safety with not the proper definition. These things we have to consider very carefully. Moving on to the international level. International level, this is the data management. We have to have objective data to compare different reasons as to why this has happened, how to address the situation. So to have a very good definition of the serious injury is very important about all different stakeholders. I hope that this is enough answer for you.
Thank you. Next question, please.
Good afternoon. Thank you very much for a very informative presentation to the panel. My question is with regards to the recommended practices. So it is said that recommended practices by nature are not meant to be binding, whereas in some instances we are expected as member states to comply with them. In terms of there are protocol questions that are derived from the recommended practices. Equally, we are supposed to file differences. My question is this area not requiring certainty, does it not create problems, not only for the member states, but also for ICAO in its responsibility of monitoring implementation of the said recommended practices? More especially when we do not have a definition of what is a significant safety concern. Thank you.
Thank you for the question. Actually, I think I could perhaps offer a reply, and part of it maybe Denis on the safety oversight perspective can complete and correct me if needed. I used to be a safety oversight auditor. So what I can tell you is that, yes, we have a comprehensive review of how a global safety system works in a state. And we'll certainly check what is the degree of implementation of all the ICAO rules, including the recommended practices. However, they are not legally binding, so Denis will perhaps expand on that, but we will certainly not, for example, issue a finding because there would be a lack of implementation of a recommended practice. Now, I'd like to come back to what you said about significant. There is a difference between reporting in the IP on these differences that are significant for safety and what ICAO reports as significant safety concern. That's not the same at all. So yes, the IP says that to report on these differences from SAPs and PANs that have an impact on safety, and it's not defined by ICAO. But when we look at how states often implement their obligations in transcribing the ICAO rules into their laws, we see that often a state might not necessarily make a difference between standards and recommended practice. They may have the same legislative weight for these rules in their own laws. So that can happen. It's why it's important to have this reporting on the differences. I'm not sure whether Denis wished to complete.
Merci.
Thank you.
Thank you, Benoit. Thank you for the question as well. Basically, is when and I'm going to go through the USO program, which is another one of my portfolio here. When I go and check the states in regards to discharging their responsibility to looking at their system through protocol questions, and basically what we're looking at, if they indeed is the states are meeting the requirements or not, and if they're not, have they filed a difference? And from there, basically, we have a single report to a state that provides them more or less the health card to the DGCAs of how their system is performing. We have obviously a humongous database of differences, of which standards being applied or not in each of the states, the recommended practices, and so on and so forth. But what we have to realize is that there's close to 12,000 standards through the annexes. So it's impossible to go and through a comprehensive audit in a reasonable amount of time with 7 or 8 inspectors looking at the CAAs if we would have to look at all of the applicable standards and recommended practices. So the usual program is built more or less as a system base. So we're asking questions to states in regards how do you discharge your responsibility? And we're trained auditors, assessors, basically, of the system. We're able to make an educated evaluation through criterias if indeed a state is meeting or not the requirements. So that's one thing. The second thing I want to say is that ICAO is upgrading its capacity right now and being able to look at all the data that we have, to be able to understand better where we have meeting the requirements or not in the applicable standards, which I think is going to yield quite a lot more substance, I guess, to the program, and as well to help us in regards to where we should be able to invest more resources and implementation, help other states. Hopefully I've helped you with that question, Benoit. Thank you.
Okay, thank you so much. So I think I'd like to conclude this session. If you have any burning question, you can talk to our panelists during our coffee break. As a teacher, I can see that sometimes body is here, soul is away, but audience, I can feel that your body is here, your soul is here. I really like the level of concentration, level of attention. First of all, I really appreciate that. Really thank you for our panelists for such an engaging, interesting, really informative session. Please join me in the panel for this great session. Thank you.